Welcome back to Watch Your Assets, where we've got your money on our minds. I'm your host, Stephanie Bracken, and joining me today is Dan Carr, the founder, owner of Carr Law LLC. He is a lawyer based in the Pittsburgh area, and he is a wealth of knowledge about estate planning, trusts specifically. I endearingly call you Mr. Trust. I don't know. I'm sure you didn't know
I'll take that. No, that's perfect.
I call you Mr. Trust.
All right.
But yes, we're so happy to have you on today, Dan. So thank you so much for joining us.
Thrilled to be here. Thank you.
Absolutely. Let's start with just a little bit of background about yourself and how you got your practice up and running and what you're looking forward to in the future.
Sure. Yeah. So yeah, like you had already said, I'm the owner attorney of Carr Law LLC. It is primarily an estate planning focused practice. And that's by design. I believe wholeheartedly that estate planning is an important enough practice area to where it really warrants the specialty of focusing solely and exclusively on that. Now, there's a wide gamut that falls under that umbrella, but that's really where our focus is. And I have kind of an eclectic background, I think, for the stereotypical attorney. So I have multiple degrees. I have a psychology degree I have a bachelor's in psychology, and I have a master's in organizational psychology. And so prior to getting my law degree, I worked in human resources for organizations such as Estee Lauder in Manhattan, and then I worked here in Pittsburgh at Highmark. And so in there, kind of helped them as they went through mergers, and really worked on more the human capital side of things, where you kind of help integrate different cultures as they're acquiring different companies and growing and expanding. So always working on the human element side of things. Then I pivoted over to the practice of law, and I worked for a mid-sized firm coming out of law school where I practiced in both estate planning as well as litigation, and learned pretty quickly courtroom wasn't really for me. I think you love it or you hate it.
Mm-hmm.
And I enjoyed my time there, and I'll tell you what, it really enriched my practice. It taught me where things can go wrong. You really get to learn what lands people in court, how things could have potentially been avoided on the front end, and how can you help, maybe keep people out of those troubles. So when I started to focus on that, I really, implemented that into designing my practice, learning what I took away from the litigation side of things, and how can I apply that on the front end so that people never end up here in court in the first place. Yeah. So opened my practice about 2 years ago, and we're growing bit by bit, and that's really kind of it in a nutshell.
Yeah, I mean, you're definitely making waves in the Pittsburgh area and beyond. So that's awesome. And we're so happy to partner with you as well. So I want to dive into the meat and potatoes of this thing.
Yeah, let's do it.
So obviously you're an estate planning attorney, and I want to specifically talk about trust because I know that's kind of one of your almost specialties, if I can call it that.
Yeah, for sure.
But I want to start maybe high level and just talk about what is estate planning and why is that important to have an estate plan?
Yeah. And it's a really important part to peel back. I think that there's a lot of common misconceptions around estate planning. I think that people think documents, they think wills, trusts, powers of attorney, and that's really kind of the focus. And what I have to say to that is, when done holistically, the documents are more a byproduct of an overall estate plan. Mm-hmm. What I mean by that is, it's not just about the documents. It's about getting to know clients, getting to understand clients. It's about merging different things, such as financial planning, helping families get financially organized. There are times that I'm meeting with families, and it might be the first time that they're sitting down and ever going through their assets and really mapping out everything that they've owned. And, sometimes it's one spouse handles all the finances, so the other one's not necessarily looking at those. Mm-hmm. And in fact, I see that quite a bit. Yeah. So it's really a time that I encourage people to get together, go over your finances as a family unit, figure out where you are now, figure out maybe what your future goals are. And so when you look at estate planning that way, it helps realize that, hey, this isn't just about putting documents in place to prepare for your death. It's actually setting up protective measures for your family while you're alive. It's a plan. If done, in my opinion, if done right, you can set up organic plans that grow with families that can adjust to their lifestyles, fit their goals, and be maybe easily amended as their lives grow and change with the future.
Yeah.
So to me, that's how I look at estate planning. It's more holistic in that regard.
Absolutely.
So it's not just about the documents, it's about the planning.
Yeah, absolutely.
Yeah.
And I think taking the whole picture into account is part of it, because you can't just look at one thing in a box. It all has to work together, or else the plan, from my perspective, at least as a financial planner, if one part of the plan is not working, then the whole plan is shot.
Yeah, absolutely. And I'll tell you what, when collaborating with different professionals too, because that's something that I do often, and it's something that I encourage every practitioner to do. And it's because we have different perspectives. So, there's times that financial planners might be looking at, hey, what are the most advantageous things that we can do now and set this up in the most tax advantageous way in the future, but might not necessarily have a full picture on how everything transpires after somebody passes away, or, so the probate side of things. And we'll get into what that is, down the road here. But so that's where I think it's really great to be able, and vice versa. For an estate planner, there are things that I could do where I'm focused solely on how things might transpire in the future. And if I'm working with, tax planners or financial advisors, making sure I'm not stepping or creating any landmines, tax-wise for those people in that plan, and really making sure that it is a comprehensive, all-encompassing plan.
Absolutely. Yeah. Now I heard you say protective measures around someone's estate plan. Can you talk a little bit more about what you mean by that?
So when setting up protective measures, so what I really mean is protecting. We spend our whole lives building. We spend our whole lives growing and accumulating assets. And we want to make sure that when we are acquiring these assets, that we're also putting measures in place that can really protect our family and our legacy, meaning that everything that we've built, and what I often see people, if they think about estate planning as just documents that they're going to put in place when, maybe right before they pass away, or they really only matter when you pass away, then oftentimes you're scrambling to put things together in the 11th hour. And sometimes it's too late. So things happen, when you do a comprehensive estate plan, you could put protective measures in there that it can factor in how your minor children can be protected if anything were to ever happen to you while they're still minors, just to ensure that they don't get a windfall of money the moment they turn 18. There's there are contingency plans that you can put in there in the event of divorce or creditors, or making sure that there's options to amend certain aspects of it for comprehensive tax planning, because we see changes in the code all the time. And so when you make sure that you can set up all of these different protective measures throughout. So let's say even, maybe somebody becomes disabled, and that's not something you can ever plan for fully, maybe you can plan for it, but never anticipate, And so what you can do is put things into your documents that are prepared to handle that in the event that somebody does become disabled, so that you can actually allow them to be able to still get, certain, state and federal benefits without any assets necessarily being owned directly in their name to disrupt those. So when talking about protective measures, it's pretty broad. It's all encompassing, and there's a lot of things that people don't necessarily think about. And I think that that's something, where I would say my psychology background comes in handy a little bit, is that when I meet with people for the first time, I try to treat it more like a counselor role. I really want to get to know you. I really want to understand what your goals are. But in that too comes an education portion where, hey, let me explain not only what these documents are, but here's all of the different things that they can provide. And you can put these different stopgaps in there that really can help shore up that plan in case anything happens.
Yeah.
Yeah.
And I think when you're not a professional or you're not in that world every day, it can be easy to overlook certain things that might be top of mind for you, but somebody might not even have considered, what if I become disabled, or what about, a blended family, things like that make things a little more complicated, that you see every single day, and you're able to help them and counsel them through that, like you just said.
Absolutely. Absolutely. And so, blended families are a great example. I mean, I think last time I looked at the statistics, it was something like, I think 65% of men will remarry. I think women slightly lower, but it's very common for people to remarry after a spouse passes away unexpectedly, And so what are maybe some protective measures that we can put in place in case they remarry to ensure that the children that you have as a couple when you're designing your plan don't inadvertently get disinherited after a remarriage, And so so it's getting people to look at things a little bit differently, ask themselves some tough questions. But to your point, I mean, I'm highlighting issues that you're never going to think about that. Just a common person thinking about their estate plan. We don't, we try not to think about all the things that could go wrong in our lives, and that's where being able to do that in a way where people are comfortable to hear the information, they're not resistant to hear it, and setting up that environment where, hey, this is something that we should think about, make sure it's an organic conversation that we're having, but that we are, we're not blinding ourselves to things. We got to be able to consider these. And I think that, again, that's kind of where some of my experience in the court has come in handy for that, where it's, hey, we can see how these things can go wrong if not properly planned.
Yeah. And death is not an easy thing to talk about, and disability, not an easy thing to talk about. I think a lot of people put it off because they think they're going to live forever. They think something is not going to happen to them, but you just never know.
Yeah. The one I hear often is sometimes people don't want to plan because they almost think that putting things into writing almost might bring about something catastrophic. And it's almost like allowing yourself to think those things can almost bring it about. And so I think it's important to find the right fit when you're working with an estate planning attorney. And I think it's important to make sure that you have a good rapport with them. Because ultimately, if anything did happen to you, this is the person who's going to be working with your family. So you want to make sure that it's somebody you think you think your family would be in good hands. And so I think when you start bridging these conversations with people and you do it in an authentic way, you inevitably start to build a relationship because you're asking them to be vulnerable. You're asking them to really, here's all of my finances. Here's all of my, they're basically opening the closet doors and letting you peek inside. And you're like, all right. So they have to trust you, And
absolutely.
So when they start doing that, you start having these conversations, it really does build a really authentic relationship. And I think it's important to, for both sides to be open to that.
Yeah, absolutely.
Yeah.
Well, let's talk about trusts. Again, I called you Mr. Trust.
Yeah, let's do it.
Because I've heard you talk about them a lot whenever we meet with you and our clients. I know that's one of the things that you like to mention as kind of a supplement maybe to a will, or as part of your estate plan, to not just be a will or that healthcare power of attorney, whatever it is. So can you talk about what a trust is if we're just starting like baseline case?
Yeah. So I'm going to actually talk about it in comparison to a will.
Perfect.
If that's all right. Yeah. So I think the will is what most people are very familiar with.
Yeah.
So, it is I hereby leave all of my belongings to, my wife, or I leave everything to my children in equal shares, and you reduce that to writing. Now, what people don't fully realize about a will is it doesn't actually go into effect until you pass away. So at that time, while it is a valid legal document, it's going to sit there and wait until the time that it's needed when you ultimately pass away. Now, wills are somewhat limited on how they can be designed and what you can distribute or sorry, not what you can distribute, but the structure that you can place within a will and how things can be distributed. But a trust is, it's more of a living document. It's something that is drafted for your lifetime. So when you draft a trust, it goes into effect immediately. Now, what a trust is, it's bare bones. It's an agreement. You're basically signing a contractual agreement that basically says, I hereby agree to take care of all of the assets within this trust for the benefit of my named beneficiaries. Now, I tell people, think about it like a wagon. Picture you go on a beach vacation. You got a couple of kids. You're packing a wagon full of a bunch of assets. You're full of a bunch of stuff. You got your lawn chairs. You got your umbrellas. You got your toys. You're hauling it. And you're ultimately getting from A to B. Well, trust is kind of like that, where you're putting your assets into this wagon, and while you're alive, you're the one steering the wagon. You control where that goes. You can take things in and out of the wagon. You can give things away. You can sell things. You can move the parts around. It's not this rigid structure that can't be moved. Now, there's different kinds of trusts, and some that are more rigid than others, and we'll talk about that too. But just generally speaking, for what's called a revocable living trust, you're in control, and you are ultimately, you own the assets as though you normally do in your everyday life. And you can own those jointly with your spouse. You can own those individually, however you choose to structure that. And essentially, you're agreeing to take care of those assets for the benefit of your beneficiaries, who are the people you ultimately want things to pass to. And they can be people, they can be entities, they can be charities, they can be pets. I've seen pet trusts. So, in fact, I have a pet trust. So so they really are mechanisms that allow you to manage your assets while you're alive. And so the difference, again, between a trust and a will is the trust, when you retitle things into the trust and the trust becomes the owner of those assets, you can determine and dictate how those assets will be managed. And you can determine and dictate how they'll be managed both while you're alive and then after you pass. And that's really where trusts shine, I think, is being able to set up certain provisions for how you can pass those assets to your beneficiaries. So, for example, if you have minor children, I mentioned earlier, you might not want your kids to fall into money at the age of 18. And so what a trust allows you to do is, one, avoid the court process. So you don't have to go through court. So, for example, if you were to pass away with just a will, and let's say you had 2 kids and you're going to pass everything to your kids and they're both under the age of 18. Well, what happens then is you have to petition the court to set up a trust for the kids that will be held, because the state won't allow you to just pass assets to a minor child. So it has to be held for them until they turn 18. So then you have additional attorney's expenses of going to court, having to set up a trust for their benefit. And then basically those assets will sit within that trust until they turn 18. And then the day they turn 18, the court is then going to release those funds to them. Now, the way that can be avoided is if you set up a trust of your own and you dictate how you'd like that to go to your minor children. And that can be anything. It could, so I always use mine as an example, and I don't have any problem sharing what's in mine, but I have mine set up where at age 25, my kids can become co-trustee, where they can basically see how the trust is managed, how the assets in there are handled. How does a trust work? What qualifies me to be entitled to taking something out of the trust? But all of the assets stay within the trust. And then at age 30, they have the ability to take everything out for an outright distribution. Now, there are some people who might use ages later or ages earlier. You can really craft it to be anything you want. You can even create trusts that exist for their entire lifetime. So there's a lot more flexibility and oversight and design that goes into a trust to really fit your goals for your child. And we set it up in a way that can change. I've worked with people who are maybe in the middle stages of owning a business, but they have their sights set on being able to sell that business for, big money. And so what they have set up for that business right now within their trust might change, So if they end up being able to sell that for, a handsome profit, ultimately they can, they may want to change their trust to then become a legacy trust, which a legacy trust means that the child never gets a full outright distribution. And there's ways to set up protective measures in there that whatever that child inherits can potentially be protected from future divorces, future creditors, and also just reckless spending. So it adds that little extra layer of protection and oversight.
Yeah.
So there's really a lot you can do with it.
Do you need a trust and a will?
Yeah, good question. Yeah, so they do. Yeah, yes.
Okay.
That's generally my recommendation. Now, that's not me making a blanket statement saying that everybody needs a trust and everybody needs a will. It is absolutely a per case basis. But I would say anybody who sets up a trust will also have a will. And it's basically, it's called a pour over will. And so what we do is we set up a catch-all in a sense where it's as our lives grow and change and we continue to gather and collect assets, we might forget to put things into the trust. And what I mean by putting things into the trust is you actually have to retitle it. So let's say, for example, you have a home. Which is more often than not, that's people's largest asset.
Yep.
I'd say frequently that's what I see. And so we actually retitle the home into the trust. And so if somebody fails to retitle something into the trust, then it's not going to fall within those protective measures that we're drafting for the trust. So what a pour over will does is it basically it's a catch-all. And so it basically is a very abbreviated probate process where we present the will to the court and we essentially state that, we have this trust in existence. Anything that we forgot to put or was, failed to put into this trust is now hereby placed into the trust. And so you list out the assets, they then go into the trust, and then it is distributed according to the terms of the trust. So it's a way to ensure that nothing falls between the cracks. So kind of a long-winded answer there, but essentially it's saying yes. So trusts and wills work together.
Yeah. I think there's a misconception about trusts that they're only for the ultra wealthy. Is that the case?
No, not at all. Not at all. I'd actually, I think trusts are for far more people than I think the general public realizes.
Yeah.
I think that there are incredible advantages to not only the level of detail and control that we've already addressed, but they provide you the ability to avoid probate and the court process. So, I mean, do you mind me sidebarring to say, so what is probate? So probate is essentially the court process to administer your estate. So it's the idea that when somebody passes away, and this includes with a will, somebody passes away with a will, they actually have to go present that will to the court. Somebody gets sworn in as a personal representative, and they are then in charge of administering the estate. What does that mean? So administering an estate essentially is saying, I'm going to figure out what all the assets were that are owned. Because let's say in a will, instead of listing out the assets, it just says, I hereby leave everything to so-and-so. Well, what's everything?
Yep.
And I've experienced this in my personal life, where, we lost somebody in our family and we've spent over 2 years still trying to figure out what was owned, where these certain accounts were, because this person had moved multiple states, held multiple jobs, different types of professions. Are there multiple 401ks maybe that were never rolled over, other retirement accounts, life insurance, things of that nature. And it's a long, tedious process. And so ultimately what they do in probate is called marshaling the assets. So you round everything up, and you figure out what they had, you present that you essentially present that to the court, and then after all of the expenses are paid, you then distribute those assets accordingly. So Downside of probate is it can be a very lengthy and costly process. So it can take anywhere from, I'd usually say a year to about 18 months. And I've seen it take longer. I have seen there are probate cases that have been open for a decade.
Oh my gosh.
Yeah. And the costs can be high. So not only do you have court costs and things of that nature, but attorneys costs as well, because of the time commitment that goes into it. So, so when I say that trusts aren't for the super wealthy, it's the cost savings that you can get by setting up a trust on the front end it's the cost savings that your family can get. So if we think about it that way, where if you make the investment of setting up a trust on the front end, it gives you that level of control that we were talking about, that level of far more extensive planning, but then it also it saves your family so much time and money and hassle on the back end. And to be honest with you, nobody who's going through the grieving process wants to worry about the administrative red tape.
Absolutely.
The last thing you want to be doing is calling financial agencies and credit card companies and trying to figure out where everything is and what all was owned, where a trust really helps set up a roadmap. And so there are some estates that don't own very much, and maybe just a will works just fine. And and that's kind of part of our introductory process when I meet with clients too, is, let me educate you on the pros and cons of a will, the pros and cons of a trust, and then ultimately you decide. You figure out what's right for you and your family at this time. And that can change, be changed and grow. But the way that my barometer, and this is just kind of through my own experience, but the way that I look at things is if you have roughly, let's say, over $100,000 in assets, if you own a home, if you have minor children, if you have a disabled child, if you have a blended family, these are times, if you own property in multiple states, these are times that you should pause and think, hey, maybe a trust might actually be beneficial, because those particular circumstances really allow you to cultivate that plan, really formulate that planning to fit all of those needs. And it really does save your family a lot of time and money on the other side of things, so that they don't have to go through that probate process and, ultimately wonder what it is that you owned and where it's located.
Yeah.
So,
And I think selfishly as a beneficiary too, the probate process taking 18 months, like that's 18 months that I don't get my inheritance.
Yeah.
Versus the
Great
trust,
point. Yeah, no, that's a really important point.
Yeah.
So all of your assets, they're frozen.
Yeah.
So, and that doesn't mean frozen's a bit of a harsh term. Like they're not completely inaccessible, but they're tightly managed.
Yeah.
Because there are expenses. And so if you do take an advancement on your inheritance before, because there are ways to do that as long as it's documented properly and things of that nature. But if you do that and then ultimately, an unexpected expense comes in and there's no longer the liquid assets to cover that expense, it can create a problem. Clawing that money back and trying to figure that out can be a problem. So oftentimes, I know me personally, I really tread very lightly on even suggesting taking any advancements. So a lot of times, your assets do end up clogged. They wait, and that can be difficult because the expenses of probate do add up. Now that doesn't mean you can't do things like liquidate certain assets. You can sell a home. You don't have to wait till the end of probate to be able to sell a house. You can put the house on the market. It's basically the estate selling the home at that point. And then any of the proceeds received from that will go into the estate bank account. And that's ultimately what will be distributed once probate is completed. But they sit there and you have to wait. Whereas something like a trust, those assets pass immediately. Now there is a trust administration process. I don't want to completely sugarcoat that. There is some administrative work that needs to take place with an attorney to make sure that things are being, that the proper trustees are appointed, that things are being set up. Sometimes we set, I tell people to think about trusts. After somebody passes away, it's almost like a Russian nesting doll where there are trusts within the trust. So oftentimes the way that these are structured, they can break off into subtrusts. And so that takes an administration process and some oversight, but it's far less, I think it's far less cumbersome than the probate process.
Yeah.
And it can happen much faster, and it can happen out of the public eye, which probate is a public process. So
Yeah.
anything you file with the court, it can be publicly accessed by anybody. And sometimes people just don't want anybody knowing what they had,
Yeah,
and
makes
that's
sense.
totally understandable.
Yeah.
Yeah.
Now you were talking about the cost savings of probate versus, setting up a trust in that administration.
Mhm.
Do you have a breakdown of what the difference is in terms of cost savings? I mean, just like high level.
Yeah. So it's tough to say because
Yeah.
every firm is different on how they charge for probate. Now, the costs, the court costs of filing things are, we're not talking massive. But it's a few $100s here, a few $100s there. It adds up. But then we also have inheritance taxes. Now, even if you set up a trust, you're still subject to Pennsylvania inheritance tax. So we're not talking federal inheritance tax. We have to kind of wait and see in 2026 how the federal, where that number goes. But right now it's incredibly high. What is it? Close to 14 million individually, 28 million combined. That's, obviously just rough shot, but in and around there. So it's the exemption is very high on the federal side of things, but PA has its own inheritance tax. And so that has to be paid out of there. So there's still an administrative side of that, but it's, again, your assets aren't completely tied up and held up when you use a trust versus the going through the probate process. You can still have access to those things while you're going through the trust administration process.
Yeah.
So, yeah.
Now let's talk about revocable versus irrevocable trust, because I think you mentioned that before, and the revocable living trust. So what's the difference?
Yeah.
And when is one appropriate versus another?
Yeah. No, great question. So with the revocable living trust, I'd say this is the most common form of trust that we see. This is everyday trust, in my opinion, for everyday people. This is the type of trust where you, like basically all we've been talking about this whole time, where you put your assets into it. You can take assets in and out of there. You can shut down the whole trust if you want to. You can liquidate the trust and move everything out of it. I mean, it's in the name, revocable. And so what an irrevocable trust is it's more context specific. So what's the purpose of an irrevocable trust? Well, an irrevocable trust is essentially taking assets out of your name. So you are removing them from your individual ownership and you're placing them into an irrevocable trust. This means that you can't change it. You set the terms, you set the parameters, and once you put those assets into the trust, they are no longer yours. Now, there's reasons for doing this. Sometimes it is, I'd say, so most commonly, where do I see this is Medicaid asset protection trusts. So a lot of times people are concerned that they may end up needing long-term care, and maybe they would spend, they're too old to get a good premium on long-term care insurance, and they want to make sure that their assets don't prevent them from being able to qualify for Medicaid. Or if they still qualify, that the state can't come back and reclaim assets such as the home after they pass away.
Yeah.
So ways to do that are to set up a Medicaid asset protection trust, where essentially you take the assets, you basically determine which assets should be moved out of the estate, and you move those into an irrevocable trust. And it's essentially, they're, in the most simplified way, they're gifting it to this trust, and they're removing it from their name into the name of the trust for their beneficiaries. So they're essentially moving it to the beneficiaries at that point.
Yeah.
And so what that does is, after the I won't go too far down the Medicaid road, but there's what's called a 5-year look back period. So what Medicaid does when you're applying is they'll look back 5 years to see if you've gifted anything out of your estate, so that you could apply for Medicaid. And if it's within that 5 years, they will issue a penalty period based on the size of the asset. So they have their own calculation that they use to determine, based on the fair market value or the actual value of what it is that you transferred, and determine what that penalty period is. So if you clear that 5 years, though, then you don't have to report that gift that you made to the irrevocable trust on your Medicaid application.
Yeah.
So it's a way to help people remove things from their estate in order to allow them to receive those benefits in the future, potentially,
Yeah.
if they need them. That option is there. Now, there's other types of irrevocable trusts as well. So there are some asset protection trusts that are designed for removing things out of their estate, maybe to reduce, so high net worth individuals maybe removing their estate tax burden by removing things out of their own name and gifting them to a irrevocable trust. And essentially it's a way of, in that too, you can protect assets from creditors, you can protect it from there are certain tax benefits, and it really, so it's really case specific. And so irrevocable, where I say revocable are more for the common everyday people, I would say irrevocable trusts are more case specific, and they have very specific benefits as to why you would use them.
Are there, whenever you move assets into an irrevocable trust, is there tax consequences to doing that?
So it depends.
Okay.
It depends. It depends on how you set it up, and it depends on. But a lot of these things, a lot of times it can be. That's part of the planning process. So you lay all that stuff out on the front end and make sure that you're doing the thing that's most advantageous for you ultimately on the back end.
Yeah.
So, but yeah, so it's kind of case specific.
Yeah. Are there assets that should be placed into a trust versus others that might not? You shouldn't do that?
Yeah.
Okay.
Yeah. So that's a really good one. So you always want to take into consideration certain tax consequences. So when you set up a trust, not everything can go in there. So it's not always, so yes, you should always consider should, but can you as well?
Yeah.
So, take retirement accounts, for example. Those don't get moved into the trust because those have beneficiary designations, and ultimately the way that they get their the tax advantages of those accounts to begin with is the individual ownership and how that's set up. And so you can't take that away by moving it into a trust. So those sit basically outside of a trust. Now you can name the trust as the beneficiary, but you always want to make sure that you're being very careful about that as well. And making sure with things like RMDs, how's that going to impact the distributions? And because the trust is technically not, a trust can be considered a qualified designated beneficiary, but it has to be set up in a particular way to allow it to do that. And when it does that, you also want to take into consideration, is it the most tax advantageous thing for me? Because trusts are taxed at a higher, the scale escalates much quicker within a trust. And so you can hit those higher percentages much more quickly. And so you want to make sure that you're being very conscientious of that when planning it. And is it more advantageous to just name an actual beneficiary on some of these accounts? And so oftentimes what you might see is, somebody names their spouse as the primary beneficiary and maybe names the trust as the contingent beneficiary of these things. And, and then let the trust dictate the terms essentially there. Yeah. So, and there's ways to, make sure that you're properly planning for that too, to make sure that you don't hit those, to the best of your ability, don't hit those high tax consequences.
Yeah.
Yeah.
Something we didn't talk about, I don't think, is like how trusts can help plan for incapacitation.
Yeah.
So if we want to talk a little bit about that.
Yeah, absolutely.
Yeah.
Yeah. So special needs trusts.
Yeah.
So sorry, I think my brain went in a different direction. So incapacitation.
Yeah.
So
We can talk about special needs trust too at some point.
but I don't know why my brain went
That's
different.
fine.
We'll do both.
Yeah.
So incapacity.
Yeah.
A trust allows a trust. So you have a power of attorney, and that will come with every estate plan that we do as well. So I'd say that with a trust plan and a trust package, it will generally come with revocable living trust, a pour over will that we discussed. It'll come with a power of attorney. It'll come with a healthcare power of attorney. And so those are like your standard forms. Now there's other ancillary documents that can be put in there as well. But that's like your standard base trust package. Now, power of attorney does allow somebody to step in and act on your behalf. But I guess the kind of belt and suspenders and something that works in parallel with it is when you have things in a trust, there is no, as long as you have a successor trustee or maybe even a co-trustee, so if it's you and your spouse that own the trust together, they can essentially step in and still act and operate all of the assets that are held within a trust while you are incapacitated. And so it allows somebody to, one, never have to involve the court if you don't have the proper documents put in place, to appoint a guardian of an estate to manage those things for you. And it allows you to, so it basically allows somebody that you've designated, you've appointed, and you've given instructions to on how to handle your assets if you're unable to do that. And so, one of the things, I skipped right to special needs trust, but that's kind of a contingency that we bake into some of these trusts as well as just kind of a backup security measure. Like, what if you were to become disabled? What if something happened, God forbid, a car accident or something along those lines, where you're in need of that, and the assets specifically owned by you are preventing you from being able to get the assistance that you need. Well, it allows things to then be shifted into a sub-trust for special needs that essentially allows you to still be able to be eligible for those benefits.
Yeah. And you can set that up for a disabled child too, right?
You can.
Okay.
Yeah. We often do. And so it's a way, disabled child, could be a disabled adult. It could be, a disabled minor child. It doesn't, basically what it does is it allows the assets to be held by the trust and out of their name individually, so that it doesn't, and the distribution of any of the funds in there that might be held in there can be managed with careful oversight to ensure that they don't disrupt the eligibility for the benefits that they're relying on for their lives.
Mm-hmm. If you have a disabled child and you do set up a special needs trust, do you, in the trust document, is that where you set up something like a conservatorship or a guardianship, or is that part of the will?
So yeah, you can set that up so you could set up the trustee within the trust, but as far as the guardianship, that's generally something that we would put into the will.
I see.
And oftentimes, like, it's important to have them all done together because all the documents communicate with one another. And so you don't ever want to, I don't say don't ever, but because I think it's better to have a plan in place than no plan in place. But when you do it piecemeal, you run the risk of conflicting documents. One document saying one thing, one document saying another thing. Well, which one controls? And then ultimately, a court has to decide that. So then, you're back in court. You're trying to figure these things out. So it's better to have them all drafted, ideally by the same person and at the same time, so that your documents all, say the same thing. So there's multiple locations that you can put that into. Like, you could put that into a power of attorney. Generally, I'd say we put something like that into a will that would determine who would be the guardian of anybody who needs it.
Yeah. If you do have conflicting documents, how does the court determine what is the ruling document?
Sure. No, good question. That's you basically have to present testimony.
Mm.
So you present the documents, you lay the facts out, and sometimes it's uncontested, sometimes it's contested, depending on what the issues at hand are. And I'll tell you what, guardianship is a big one. So and this is where you will see families battling it out, and it's not. I don't know. We think about court, and we think sometimes like there's a clear winner, and there's clearly an aggrieved party, and it's not like that. And oftentimes it's two people who think that, so with a guardianship, you might have different family members that are stepping forward each to take care of a child. So it's really genuine what they're doing, and they each think that they have the child's best interest in mind, but you end up fighting because you think that maybe you have a better claim to being the guardian than another party. And if it's not spelled out correctly in the documents, or if it's ambiguous, or if it's not spelled out at all, it can really set up for an unnecessary fight, and ultimately the court then has to decide who's in charge, and it's not always going to be who the parents maybe would have wanted.
Yeah.
Because you think about the things that a court has to look at. So they might skip right to the financials. Who's most able to do this, or it's. I hate to say it's surface level, but it can be. So let's say you had a one sister that you wanted to raise your kids, and she's a little bit more of I don't know, let's say a bohemian kind of mentality. You know what I mean?
Yeah.
She's kind of go with the wind, but she, deeply aligned with your morals and traditional values, the values you wanted to pass along to your kid. And that to you was the most important thing. And you provided for that kid. You provided the finances in your trust. So you have the financial part's not something you're taking into consideration. It's maybe, it's maybe the values. It's who kind of aligns with how I would want my children raised. And but let's say that sister maybe has inconsistent employment, and you have another sibling that steps forward who's great job, great on paper and on the surface looks like they're living the picture perfect life, but that's maybe a sibling you never got along with, and that their values don't align with yours, and it's not where you wanted your kids to go at all. And it might sound extreme, but I mean, these are the types of things that you see where it's like, on paper, one party might not look like the most suitable party for it, but maybe that's not what your goals were. And so that's where these things really become important. When I'm telling people to set up something like a guardianship, I always tell them, don't think about the money. Like, don't put that at the bottom of the list. Really aim for who aligns with your values. Who would you not bat an eye handing your kid over to, and trust that they would really take care of your kid? Because the financial component, I mean, that's why we set up things like our life insurance policies, and that, and those are the things that are in a trust to take care of them as they're growing up. But you can't replace somebody whose values align with yours. You know what I mean? So it's I usually, and it's a tough one, because sometimes you have couples that completely disagree, and so I even have, it's funny, but I almost treat it like couples therapy. I have like exercises that I have couples walk through if they're struggling to come up with this. Sometimes they'll rattle them off and it's no problem, but there's other times where they have disagreements on who it should be, and usually what I have them do is make independent lists and list out anybody who'd be better than foster care. And that list can get pretty long pretty quick, but when it's almost like free form writing, when you're not thinking about it, like names just start coming out, and you're like, oh wow, okay, you know what, I hadn't really thought about that, but they might be great. And then we narrow it down to a few, and then we compare lists, and we see, why did you choose these people? And then it just facilitate some conversations and get people thinking about these things.
Absolutely.
But that's some of the tough stuff that you don't really, I don't know. Couples aren't looking to always start conversations that are going to create arguments. So sometimes it's great to have somebody there to facilitate that and help them, kind of bridge that, or maybe think about it a little bit differently. So, yeah.
I have to imagine you've seen some situations where siblings disagree with what their deceased parents
Oh yeah,
thought or wanted or put into place.
sure.
And we had a client like that where the dad named him as the kind of sole beneficiary,
Hmm.
but he had several other siblings that all wanted a piece of the pie.
Yeah.
And I think they may have won actually in court,
Oh,
which is, I can't remember if that is exactly what happened, but something along those lines
yeah,
that,
I'd be surprised. Wow,
yeah,
that there maybe there's because there's really specific things that you have to prove
yeah.
because there's no so here's the uphill battle that people run into with that is there's no legal right. You're not legally as a child, you're not legally entitled to anything from your parents.
Mm.
They can write you out. And where it even gets more complicated is stepkids. So
Mm.
the law it doesn't automatically recognize stepchildren. So you have to make sure that you're including that in your definition of children in the documents or excluding it if that's not what you want to do. But you want to make sure that your documents are specific on how that's handled. But there's no automatic legal entitlement as a child to an inheritance. And so, in order for them to win in court, you'd have to prove um, there were some missteps along the way, and,
Yeah.
and that can happen. Maybe something was drafted in the 11th hour, and maybe there was undue influence or, falsified documents. I mean, you usually have to almost get into that level of it in order to get it overturned at that stage.
Yeah.
And sometimes those things do exist, but yeah, but for spouses there is a legal entitlement. Like you can't
Yeah.
disinherit your spouse, so they can take what's called an elective share. So if they were written out, they can choose to take a particular share that's laid out in Pennsylvania statutory code that says, hey, this is what the spouse is entitled to. But
Well.
kids don't have that protection.
Hmm.
So yeah, it gets interesting, it gets dicey.
Yeah.
And it's yeah, when asked to draft those things, we make sure we have very thorough conversations about the impacts of that,
Mhm.
because I will be the one to, whatever attorney is overseeing it will ultimately be the one to have to deal with that,
Yeah.
and so it's important to make sure they're going in with eyes wide open. And so it's never to talk them, certainly not to talk them out of what their wishes are, but it's also just to make sure that, hey, make sure we're illuminating this so that you understand, potentially what might be coming around the bend.
Yeah.
So
How often should somebody review that plan just to make sure
yeah,
things are up to date? If there's a new grandkid in the
yeah.
mix, what kind of life circumstances would warrant an update to your estate plan?
Yeah, it's super important. I just saw this. I just saw this week where I went to go open a probate estate, and it was a will that was drafted 30 years ago, and it was missing some really simple and what I would consider standard key provisions in a will. So the daughter had flown in from Indiana to do. She flew in from out of state to basically open this estate, and then wasn't able to do it at that moment because we have to get some extra documents in place. And it was stuff that really simply could have been avoided
Mm.
if reviewed. A 30-year-old will. So how often? So I generally do. I do 3-year reviews for my clients, and so I basically, as soon as a plan is executed, that goes on my calendar. So in 3 years, they'll basically get an email from me or a letter from me that states, "Hey, here's some qualifying life events that take into consideration. If any of these have happened in and around your life, let's come in and review your plan
Yeah.
and check it out and see if anything needs to be updated." So I would say minimum 5 years, especially if you got your plan drafted on the younger side of things where
Mhm.
life happens fast.
Yeah.
I think about I have a 5-year-old and a 3-year-old, and I think about how much life changes in 5 years and how much it will continue to change in the next 5 years. It's important to make sure that those documents still reflect what your intentions were when you first put them in place. It's not a set it and forget it, and that's the important thing. And so I think I think it's really important for people to get those plans reviewed. And so second part of your question, what are some of the things that warrant a review?
Yeah.
And it could be you know, buying and selling a new house, especially if you have a trust in place. So if we need to get if we didn't do it, if you didn't come to me or your attorney when you were purchasing and selling that new home, then we need to make sure that the new one is now placed into the trust as well, so that your documents do what we've designed them to do. Were there any losses in the family? Did you come into any inheritances? Did you get divorced? There's certain things that are, I almost look at it like healthcare, how there's certain qualifying life events that qualify you to be able to enroll in healthcare. It's somewhat similar to that, where there's certain qualifying life events that really should trigger that.
Yeah.
Did you open a new business? Did you sell a business? Did you retire? So at different stages, it should be reviewed, because what plan made sense for you at a different stage of life might not necessarily make sense for you at this stage of life.
Yeah. What about whenever like somebody's first thinking about putting an estate plan together? Is there a certain milestone that people hit? Is it a certain age that people hit whenever they first should have it? Is it a child? Is it a marriage? Is it a house? Yeah.
Yeah, that's a good one. It's probably just a byproduct of my industry. Anybody over 18 could and potentially should have a plan. And I think that's something that parents don't think about, is that when your child turns 18, you no longer have a say over their finances or their health care. And so if anything were to happen to them, especially if you're sending your kid off to college, God forbid something happens to them, you're no longer in charge of their medical decisions, and their finances. And it's a great time when your kid's getting ready to go off to college, get some simple, super affordable, easy documents in place. Get a power of attorney, get a healthcare power of attorney in place. That kid, I'm not saying he probably doesn't need a will at that point, but get those couple of things in place so that way, if the parent ever needed to step in, they don't need to involve court to be able to do it, because that's the last thing you want to be thinking about when you're going through these things. So I generally recommend, going off to college, those are some easy documents to get in place that can last them a very long time. But yeah, I think any major milestone should get you thinking about it, especially I think kids is a must. If you have minor children, you absolutely need to make sure that you have a guardianship in place for those kids. You absolutely should make sure that they don't just come into an inheritance at a young age, or that you'd have to go to court to get somebody appointed to get a court-appointed trust, because they're going to choose the trustee as well, so it's not going to necessarily be your wishes. And like we talked about already, they would choose the guardian, whoever petitioned the court for, who's eligible for it, petition the court for it, essentially, could become guardian of your child.
Yeah.
So you want to make sure that those things are very much in place, and it's easy to do. It's not something you want to wait until it's too late.
Yeah.
So, but it really, any milestone throughout life, it's never too late. And to, my earlier point about turning 18, it's never too early.
Yeah. I never even thought about getting a healthcare power of attorney for someone who just turned 18.
Yeah.
I think about that for somebody who's like in a nursing home, that has dementia, that you want them to be taken care of, but never even considered the fact that a child couldn't, or an 18-year-old, if they're incapacitated, who makes the medical decisions?
Who makes the decisions?
Yeah.
Yeah. And especially the tough decisions.
Yeah.
And so it helps get an understanding, one, of what your kid's wishes are when making those documents. It helps facilitate some of those really difficult questions. It's probably the first time a child and a parent would have that conversation. And I know as a parent myself, it's the last conversation you ever want to have with your kid.
Absolutely.
But just because it's a hard one to have doesn't mean you shouldn't have it.
Yeah.
So, and I think that when you, again, create the right environment for those conversations to take place, and they can be a little bit easier, but they definitely shouldn't be avoided just because they're hard.
Yeah. That can be said about a lot of things.
Yeah, for sure. For sure.
Yeah. A lot of tough conversations have to go on in life, but you have to have them sometimes.
You got to do it. Yeah, because it just creates, it really creates problems. This is the other part of my business, is that I do the administration side of things as well. So not just trust administration, but probate administration as well. And or I get a call in the 11th hour. I've had to do bedside plans, and it's a tough thing to do. And it's, there's higher level of criteria. You got to make sure, are they mentally capable of making any decisions right now? And so, I have to go through my own evaluation process with that. And it's heartbreaking to see, and it's very difficult to do. And it's the last thing you want to be thinking about in those moments. So,
absolutely.
It's better to plan ahead.
Yeah. Is there anything we didn't cover that you wanted to cover?
I think one thing I didn't touch on was businesses.
Yeah.
I think that, when you're asking my list of who should have a trust, I'm not sure if I listed that one off or not, but if you're a business owner, having a succession plan in place is huge. Making sure, especially if you have employees, so you want to make sure that you have somebody who can step in, keep operations going. So, expenses aren't missed, payroll's not missed, clients don't, client obligations don't go unfulfilled. You really want to make sure that you have a succession plan in place. And this is another thing with probate. If you don't have that business set up within a trust and it ends up clogged in probate, then it's waiting there, and it can be difficult to have a business tied up in the probate process. Again, that lengthy process while it's sitting there tied up waiting to be administered. So if you have your succession plan set up within your trust, it can be, I'd say, relatively seamless. Obviously any transition like that is always going to be difficult, but it doesn't have to be, overly difficult.
Yeah.
So,
well, this is a lot to take in.
Yeah.
And I think at the end of the day, what I'm taking away is that everything that you do is very personalized, and it is very specific to that person's situation. It's not a one size fits all. Not all wills are the same. Not all trusts are the same. Your estate plan is going to look my estate plan is going to look completely different from yours. And that's where your expertise comes into the mix.
Yeah.
So thank you so much for all of your insights today. If someone does want to get more information from you or about your business, want to talk to you, where can they find you?
Yeah, no, thanks. I appreciate that. So the business is Carr Law LLC. I think all of my social handles are Carr Law LLC. On Instagram, Facebook, LinkedIn. You can go to my website, carlawllc.com. And I'm always happy to talk, and that's the thing, is that I really make the effort to connect with people, even if they're just calling with questions, because a lot of times that's what let's say, somebody loses a family member, they don't know where to start. And so, I think being a resource is really vitally important. And so I'm always happy to chat and answer any questions and sit down for any meetings to discuss things further.
Yeah, that's awesome. Dan, thank you so much for joining me today.
This is wonderful. Thank you. I
hope you had fun.
Yeah, I did. I had a lot of fun. This is awesome.
Yeah. Well, if you enjoyed today's episode, give us a like, give us a follow on all social media platforms. It is Watch Your Assets, and we will see you on the next one. The opinions voiced in this podcast are for general information only and are not intended to provide specific advice or recommendations for any individual. To determine which strategies or investments may be suitable for you, consult the appropriate qualified professional prior to making a decision. Securities and advisory services offered through LPL Financial, a registered investment advisor, member FINRA/SIPC.